Good day everyone, I am Krizza Benitez from PCBet 01401A, the assigned reporter for incorporation and organization of private corporations, focusing on Section 11 where we will be discussing about the following. First is the signatories of Articles of Incorporation. Next, the designation of incorporators as directors or trustees. We will also tackle about the foreign nationals in the Articles of Incorporation and what are the additional requirements for certain corporations. And last is about the revival of corporate existence. Before we start with the signatories of Articles of Incorporation, ilagay muna natin yung sarili natin sa position na nasa business world na tayo and alamin natin why it is important for our business to be incorporated. First, it provides personal assets protection. Unlike sole proprietorship kasi, once na may mag-file ng lawsuit about your business, pwedeng madamay yung mga personal assets mo. Pero sa corporation, since it has a separate personalities from its owners, may sort of boundary or shield ang mga shareholders pagdating sa mga liabilities o mas kilala sa tawag na corporate veil. Second naman is tax flexibility. Your tax advisor can help you with the structure to pay yourself some of your earnings as personal income and the rest as shareholder dividends. This is important kasi yung shareholder dividends are typically taxed at lower rates than personal income. And last is yung credibility. Yung pagdadagdag kasi ng INC or Incorporated or LLC kasunod ng business name mo will provide credibility to the consumers, vendors, and partners mo. Unlike partnership, corporation cannot be created by mere agreement or just meeting of minds because it is a contract. Forming a corporation has a very specific set of requirements. Among them are Articles of Incorporation. Articles of Incorporation form a document that establishes a corporation as a separate business entity. The articles become a public record and provide important information about the corporation. I will not further explain this part because it is involved in the topics of the next reporter. So who is or are the signatories of Articles of Incorporation? From the previous topics, we've learned about the different components of corporation, namely promoter, corporators, and incorporators. The incorporators are the ones as originally forming and composing the corporation, having signed the Articles of Incorporation. These incorporators have no powers beyond those which are vested in them by the Articles of Incorporation. There can be only one set of incorporators who appear in the Articles of Incorporation. As long as they appear in the articles, they will remain as incorporators until the corporation is terminated. So kahit na umalis yung incorporator or mamatay siya, he will be always an incorporator hanggang sa ma-terminate ang corporation or yung business. Kasi ang Articles of Incorporation cannot even be amended to change the name of the incorporators. Kasi it is an accomplished fact na hindi pwede baguhin o bawiin ng current law natin ngayon. Kaya mahalagang i-file, reviewin, at agreed by the signatories ang nilalaman ng Articles of Incorporation. Under Section 10, incorporators may be a natural person, a partnership, an association, or corporation. Sa old corporation law kasi, natural person lang ang allowed to form a corporation. Pagdating naman sa mga license to practice a profession, pati yung mga partnerships or association na organized for the purpose of practicing profession, ay hindi sila allowed to form a corporation, not unless provided under special law. Natakal na din naman natin yung iba pang qualifications ng natural person from the previous reporter. So let's move on. Each individual signing the Articles of Incorporation must indicate the capacity upon which he is affixing his signature thereto. Pagdating naman sa mga designated na pipirma in behalf of not natural person like corporation, partnership, or association, dapat indicated pa rin yung business name being represented and kung para kanino niya ine-execute yung Articles of Incorporation. Importante din na indicated ang taxpayer identification number ng principal pati yung mga designated signatories sa gagawing Articles of Incorporation. Yung TIN na tinatawag is parang student number pagdating sa ating mga estudyante. TIN is issued by the Bureau of Internal Revenue or BIR to every taxpayer and signifies that you are the part of responsible group of Filipinos that pay taxes. The BIR and the Securities and Exchange Commission have collaborated to facilitate the issuance of pre-generated TINs to corporations and partnerships as part of the registration process. Kaya importante na lahat ng files na ipapasa sa SEC ay may nakalagay na TIN. Pag may mga foreign investors naman, pwede naman gamitin yung passport number nila, pansamantala, pero afterwards, kailangan na nila mag-issue ng TIN. Now let's proceed to the designation of incorporators as directors or trustees. The natural person who wants to be part of the corporation as an incorporator must be of legal age and they must own or be a subscriber to at least one share of the capital stock. Because the presumption here is kung yung incorporator na yon has pecuniary interest in the corporation because he gave money, then he will be concerned with the management of the affairs of the corporation. Can we consider foreign nationals in the Articles of Incorporation? As a general rule, as long as the majority of the incorporators are residents of the Philippines, pwedeng maging parte ng Articles of Incorporation ang foreign national. Kasi foreigners are generally allowed to be incorporators provided that the requirements of the incorporators are complied with and the business activity of the corporation is not fully reserved for Filipino ownership. Baka may magtanong na pwede ba na lahat ng incorporators are foreigners? Ang sagot dito is yes, basta provided that all the requirements for incorporators under the Corporation Code are complied with, and this is true for registration under the Foreign Investment Act of 1991 as amended by RA 8179 or also known as the An Act to Further Liberalize Foreign Investments. Pwede bang maging president ng isang business ang foreigner? Definitely yes. A foreigner may hold the president position provided that he or she meets all other requirements. And also, the president does not need to be a resident of the Philippines. Based sa Old Corporation Code under Section 11, dito, ang corporate term shall exist for a period of not exceeding 50 years from the date of incorporation, unless sooner dissolved or unless said period is extended a corporate term, or pwede din kung ano ang term na agreed and filed in the Articles of Incorporation. Pwede itong ma-renew by means of amending the Articles of Incorporation, but it must be issued 5 years prior to the expiry date. But if we talk about the Section 11 of Revised Corporation Code, which took effect on February 19, 2019, a corporation shall have perpetual existence unless its Articles of Incorporation provides otherwise. Dito, yung mga company is may option to choose pagdating sa kanilang corporate term. These are the perpetual existence or company will provide a fixed term in the Articles of Incorporation. There will be no perpetual existence if the corporation chooses to provide fixed terms in the Articles of Incorporation. Kasi in the first place, may option sila, and that is what they have chosen. Pero kung walang nakalagay na term sa articles, then it is deemed perpetual in existence. So baka may magtanong na paano yung mga corporation na na-organize before the effectivity of the Revised Corporation Code? Anong nangyayari sa kanila? Simply, they are deemed to have automatic perpetual existence without having to amend or baguhin yung Articles of Incorporation to approve the existence of corporate term. It is stated sa Old Corporation Code na if the term is expired, corporation is ipso facto, meaning automatically dissolved na ang corporation, pero under the Revised Corporation Code, if the term is expired, it removed the ipso facto phrase since the corporation was given an option to file a petition of revival once approved by the Securities and Exchange Commission. So, who may apply for revival? A corporation whose term has expired. An expired corporation whose certificate of registration has been revoked for non-filing of reports. an expired corporation whose certificate of registration has been suspended, and an expired corporation whose corporate name has been validity reused. In the broader interest of justice and in order to best serve public interest, the Securities and Exchange Commission in particular matter exempt an expired corporation from the guidelines in exceptional cases and apply such suitable, fair, and reasonable procedure to improve the delivery of public service and to assist the parties in obtaining a speedy and judicious disposition of cases. So, sino naman yung mga hindi na pwede mag-apply for revival? Una is an expired corporation which have completed the liquidation of its assets. Number 2, an expired corporation whose certificate of registration has been revoked for reasons other than non-filing of reports. Number 3, a corporation dissolved by virtue of Section 6C and 6D of the Presidential Decree of 902A. And last is an expired corporation which already availed of re-registration. Sa pag-apply ng revival of corporate existence, hindi naman pwede na basta-basta na lang ito. Magiging possible lang ito through voting. So what is the required number of votes to initiate revival? The required number of votes for the revival of an expired stock corporation is at least a majority vote of the board of directors, and the vote of at least majority of the outstanding capital stock. For non-stock corporations, at least a majority vote of the Board of Trustees and the vote of at least majority of the members. Nakadepende din ito sa dami o laki ng shares ng mga boboto. Ano nga ba yung tinatawag natin na appraisal right? It refers to the right of any stockholder of a corporation to dissent or hindi sumang-ayon at magdemand ng payment for the fair value of his or her shares in the corporation. Since we are talking about corporate term or existence, it may affect the appraisal right of the shareholder. Appraisal rights may be exercised anytime by the shareholders when there is automatic perpetual existence, pero kung nag-elect ang shareholder about the term or existence ng company, they are not entitled to exercise his appraisal right. So that ends my report. Thank you for listening.